Jessica Wagonseal's writing to me now. Do I exit one and join the other at the end? Yes.
I am muting, so we are starting, yes?
I would recommend we open the doors at this point. That gives people a few minutes to come in. So again, if you have your mic muted, they won't see you. So
Right,
I'm going to go ahead and mute my mic.
Is somebody going to tell me when to start? Is somebody going to say, Lori, start?
Do you want me to change my screen to red at 3 o'clock?
Okay.
I received a notice it's being recorded.
My screen is locking up. I can't believe it. Okay. Aaron Bobbitt raised his hand. I don't know what to do. What do you do if somebody raises their hand?
I think you can go under participants.
I can't see participants. I think because I'm screen sharing. All right. It's almost 3:02. So I'm going to go ahead and welcome everyone to the first seminar in the spring 2021 seminar series on education, engineering, and race. My name is Lori Seton, and I'm the co-host of the continuation of this seminar series in the McKelvey School of Engineering at Washington University. In response to vivid demonstrations of social injustice in our country, including racial injustice and acts of police brutality against Black citizens, and inequities in healthcare access and outcomes for COVID-positive patients, the school felt there was a void in our understanding of how policies and practices that perpetuate racism in our country, how we contribute to those as engineers, educators, and researchers. Through this series of seminars, we hope to learn from leading scholars that study practices that support racial inequities in engineering access and engineering achievements to better understand how our research and translation into products as engineers can alter these inequities and unjust practices. We thank you for coming today, and we ask for your engagement in engineering a brighter future for our students, our future students, and all those impacted by our work. So it is my great pleasure to introduce to you today's speaker, Professor Areto Imoukhuede, a professor of law at Southeastern University. Professor Imoukhuede earned his bachelor's in economics from Northwestern University, where he was awarded a Golden Bear Award for financial acumen, which I love, and then went on to obtain his JD from Georgetown University Law Center. He has taught U.S. constitutional law, and he's taught multiple courses of interest on international justice and the human right to education. He conducts research on the fundamental rights as duties under the U.S. Constitution. In particular, his research in education and homeland security has led him to publish articles on the constitutional duty to provide public education under the Fifth Freedom. Also an article called Freedom from Ignorance, the International Duty to Provide Public Education and Education Rights and the New Due Process. We as educators are particularly interested in understanding our obligation to create a scientifically literate population amongst our own students, and so are very interested in learning more about rights and access to education for all. So before I turn it over to Professor Imoukhuede, what I'm going to do is ask the audience to please enter your questions into the Q&A throughout the talk, and the speaker will take questions at the end. I will return at the end to ask for your engagement in discussion about today's seminar, as we'll break into small Zoom breakout rooms if you choose to participate. So with that, I am honored to introduce and turn over to Professor Imoukhuede. His slides, we'll stop sharing and ask him to turn over the slides.
Thank you so much for the wonderful introduction. I'm excited to be your opening speaker for this spring's Engineering, Education, and Race Seminar series. It's my belief that this series is crucially important, especially now. And I'm honored to join your efforts to further racial equality. So before we get started, I want to just sort of share a little bit more about my inspiration for the research that I do. I first began my work on education rights during my service as a fellow in the United States House of Representatives, where I worked, among other things, on education policy issues and contributed to a book chapter on New American Rights, the education chapter to that book. My work there inspired me to begin writing on the constitutional right to public education. Now, here's the roadmap for where I'd like to take us over the course of this hour. Begin by talking about education being essential to so many things, including liberty, democracy, and basic human dignity. Before talking about the fact that education should be a fundamental right. And I want to note that there is no fundamental right to education under the United States Constitution. But there is a right to education under certain state laws and under every state's constitution or interpretations of those. And we'll talk more about that. This is before I go into discussing the liberal equality versus racial equality concerns. That is to say, the definition of equality under the Equal Protection Clause of the 14th Amendment. Then we'll go to talking about the present day and how the current structure privileges the already privileged, thus reinforcing white supremacist outcomes, where we see racism not as this idea of one race versus another, but rather a structure that maintains a certain hierarchy. And then we'll go into the questions and discussion. Okay, you'll be seeing this roadmap slide throughout at different points as we go from part to part. That way, it'll be hopefully easier for everyone to keep track of where we are and not get lost on this journey, on this road to trying to understand potential for racial equality. So this presentation will in sum discuss the fundamental right to public education and how racial inequality in education is structured and reinforced by the law. Structured and reinforced by the law. Along the way, I will address competing definitions of equality in the United States Constitution and history, and consider the extent to which the current legal structure essentially privileges the already privileged. So on to this question of education. What makes education essential? Why is it important? So education is essential to human dignity. And this is a course subject to one of my academic papers on titled Education Rights and the New Due Process. The basic idea is that there are two components to human dignity that I'm highlighting: liberty and democracy. As I say, in order to be a fully realized human being in any civilization worth calling such, there has to be a value of human freedom as well as autonomy or agency in determining how one is governed. Liberty and democracy. So under this conception, we can see that education is essential to liberty because, like the right to privacy, education is essential to realizing your full self, the full human dignity, and also leads into the possibilities for democracy. So you can't have freedom without education is the sum total of that. And I'll talk a little bit more about W.E.B. Du Bois's Black Reconstruction and his insight about liberty being tied to education shortly. But I do want to highlight the democracy component to human dignity that is so very important with regard to being able to have agency over how one is governed, be a participant in governance. Being a participant in governance is a central theme to the founding of the United States of America. And self-governance logically requires sufficient knowledge to govern effectively, to participate fully. Now, the nation's education systems consistently guarantee a high quality, do not consistently guarantee a high quality or even basic level of education to all of its students. Now, this is particularly troubling when we look at some of the research that's been done on education to identify which students are harmed. And here you see not just some idea of generally, which is more comfortable to talk about, right? Generally, our education system has failed, but rather the specificity of those failures. Education scholar, and I believe Secretary of Education for the state of California, Professor Linda Darling Hammond, has written about the failures of the US education system for its Black and brown students, to the point that if you were to compare the US to other countries, while we fall very far short of other industrialized nations as a whole, when you take out the Black and brown students, all of a sudden we're near the top. It's very clear who's being left behind. And this goes into one of the biggest concerns that drove attempts to further liberty, both before and after the Civil War. W. Du Bois writes in great detail in his Black Reconstruction, and I talk about in my second, the Education Rights and New Due Process, this recognition that education was essential to liberty, both by the slaves as well as the later freed men and women. It was also recognized by the planter class, the enslavers, to the point that Black people who were enslaved were denied the right to get educated. In fact, they weren't allowed to be educated at all. Forget about a right, it was a crime, which of course reinforced for the slaves then the value of it and the connection of education with freedom. So there were secret education centers, and after the end of slavery in the United States, during the early years of Reconstruction, there was an immediate push for education. in the South, led by the freed slaves. To be clear, in the imagination of the poor white Southerners, there was no need for education, no need for public education. The idea is if or when I ever get paid, get rich, get money, then I'll be able to go ahead and then I'll need it. But until then, all this public education stuff is unnecessary. The South was very much a hierarchy-based society where only the elites had access to education. There was no idea of public education until Reconstruction. So all Southerners have the freed slaves to thank for the existence of public schools today. And that sort of goes to sort of a greater theme of just sort of constitutional law more broadly. The Civil War was a major earthquake in transforming the United States of America into the America we see today. What existed before the Civil War was virtually unrecognizable from the perspective of most Americans and most of those who study this country. So to be clear, today's education problem is about race. Black students and most other non-white students receive a quality of education that is far less than that of their white peers. This, surprisingly, is true even when Black students attend the same schools. The problem becomes exacerbated when they attend increasingly segregated schools. Black children are disproportionately targeted for referral and arrest by police in schools and are inevitably more susceptible to becoming victims of the school to prison pipeline, which I've also written about in the Right to Education in the School to Prison Pipeline, 2019 article. One of the most disturbing consequences of being a victim of the pipeline is that it leads to negative educational and long-term outcomes. You can imagine already the sorts of outcomes, but you don't have to imagine, right? A school to prison pipeline marks somebody in many states around this country as not being able to fully participate in our democracy. Literally, education is being transformed from a tool for liberation into a tool for oppression by way of the school to prison pipeline. Clearly, this undermines any right to public education. So now we've discussed how education is essential. We're moving on now to how education should be a fundamental right, and the reality that it is not under the federal constitution, not currently recognized as a federal constitutional right. So what is a fundamental right? Without going into a full detail of a law school lecture on this subject, I want to make sure we're clear that fundamental rights are those rights that are so rooted in the nation's history and traditions and so essential to ordered liberty, they are recognized as fundamental. And by being fundamental, that means they receive the greatest protection. Now, just to throw some legal jargon out there for those of you who have some background in law, fundamental rights receive strict scrutiny. That's the highest level of protection. And I've written on this subject of how problematic strict scrutiny as it currently is thought of can be when applied to rights like education, that would be positive rights. But I don't want to go into too much detail about that unless someone wants to talk more about that in the Q&A. Otherwise, I'll just refer you to my other works, including The Fifth Freedom. But the bottom line here is examples of fundamental rights that have been recognized include a right to travel and a right to privacy. And for those of you who are wondering, what's the right to travel? Well, it's not a right to international travel. What you have in the United States is a fundamental right to interstate travel. So you can go from Missouri to Illinois and Illinois to Missouri and back and forth, or anywhere else within the United States. The idea being that's fundamental to ordered liberty in the United States. It's rooted in the history and traditions. Mind you, this right is not in the text of the Constitution. it's seen as developing or flowing from it logically. Okay. Enter the infamous case of San Antonio versus Rodriguez. Now, this is an example of the court structuring our reality in a very significant way. This case happened not too long after Brown, and I'll be talking about Brown in another part. But suffice it to say, most people who know anything about Brown know that it stood for the proposition that everyone's entitled to education. However, San Antonio versus Rodriguez, a case where they had the lawyer who argued Brown dissenting to the case because he was now a Supreme Court Justice Thurgood Marshall. San Antonio versus Rodriguez held that there is no federal constitutional right to public education. And the structure of that holding is fascinating, right? You had Mexican-American school children suing, saying that the school funding formula in their state was depriving them of full access to education. And the court, first of all, found that, okay, a funding formula that's wealth, anything involving wealth, that would be discrimination based on wealth, except there is no protection of wealth as a suspect class. We're not suspicious of wealth discrimination. That's its own issue that is incredibly problematic and is clearly linked to race. But then they took another step because, well, we already had an impact here. There was no dispute that Mexican-American school children were impacted. And whether you want to frame this as a race or national origin issue, which is both are protected the same way as protected classes, the court said that they were unwilling to evaluate it under strict scrutiny. Actually, they said they reinforced a rule that they could not evaluate that under strict scrutiny unless they could not strictly scrutinize this law unless there was a showing of intent. To be clear, no dispute that Mexican-American school children had less funding for their schools as a group. The only issue is, well, the Texas government didn't mean to do that. You have to prove that they meant to do that. And the final issue then was, okay, with no intent, can you at least show that you're infringing on a fundamental right? Because this was clearly intended to address a right. And the response was no, because education is not a fundamental right. It's important, but it's not fundamental. Now, I want to come back to that idea that education is important, but not fundamental, because there's a later case that sort of reinforces that, so that states cannot outright deny education to whole categories of people such as undocumented children, right? Separate case of Plyler versus Doe. A state cannot say we're not going to give education to undocumented children because education is too important. San Antonio versus Rodriguez, Plyler versus Doe, side by side, make it clear that the court's uncomfortable giving full protection to the right to public education, but the US Supreme Court recognizes a right, even if they're not framing it as fundamental. Good news though, even though the United States of America does not recognize a fundamental right to public education, each state effectively does, including the state of Missouri. Now, this is one of the things that I find to be the most fascinating, right? Most people are not aware of just how progressive the legislation is, or I should say, in this case, the constitutional amendments are that create the right in their state. I've included here for your convenience the text to the right to public education in Missouri. Please note, we're talking here about knowledge and intelligence being essential, a general diffusion of knowledge and intelligence being essential. Talking about the requirement that we maintain free public schools. This sort of language, and I'll just give you on a personal note, I've served on the platform committee in the state of Florida, for a political party in the state of Florida. And when I was serving on this political platform committee, I was the education chair. It was difficult to have the meeting on my subject because I had difficulty getting people to not think I was a radical when I quoted Florida's state constitutional right to public education and saying we should have candidates back this. I mean, the scary part is if it's radical to quote existing constitutions, what hope do we have to make progress? So as you think about sort of solutions to these issues of equality, consider just reading some of the foundational laws that we have and how far they actually would go if actually people believed in them today and understood what they meant. So some states go further than Missouri goes even. Illinois, Florida, and Rhode Island recognize the right to not just education, but high quality public education. You know, while some states just limit it to adequate education, the point here is that despite these mandates, states have not consistently enforced racial equality in public education. So we are now finished with part 2. So far, I've discussed why education is essential, and we just discussed that education is not recognized as a fundamental right under the US Constitution, although it is recognized as a right under state constitutions. If states offer public education, it is required to satisfy the 14th Amendment, just as they are required to satisfy the 14th Amendment equal protection obligations for anything they distribute to the people who are in their state. So all people, not just all citizens. That's something that's a bit of a confusion for some people, given the rhetoric of our times. All people, all persons is the language of the 14th Amendment, are entitled to equal protection under the law. This is why the intent analysis of Rodriguez was so important, because even if you don't have a fundamental rights concern under education for the US Constitution, the fact that the state recognizes the right obligates it to protect it equally, or to equally fulfill its duty to provide public education. So now let's consider what the word equal means in the 14th Amendment's Equal Protection Clause. So here, I want to begin with these competing definitions of equality. Just so that we're on the same page, the 13th, 14th, and 15th Amendments were passed after the Civil War. The goal of the framers of those amendments was to reset American democracy so it would be inclusive, to reset American civilization so that it would be inclusive. Racial equality was the explicit goal, as well as broader equality. And you know, there's so many cases early on where the court undermines this, but I want to begin by making sure we're clear about what the framers intended. The intent was to define equality based on racial equality terms that was broad equality between the races. Group identity and racial status is central to racial equality in the sense that we're trying to remove that hierarchy, obliterate that hierarchy. Context matters. The American context matters when we talk about racial equality. So we fast forward to today, and you know, one way of thinking about things is, if you want, well, forget about today, but just in a very simple way, racial equality takes the contextual perspective that if you're watching a parade and I'm 7 feet tall and someone else is 5 feet tall, and we're trying to look over a railing that's 6 feet high, you don't just give somebody, you don't give both people separate stools, they'll raise them half a foot or 2 feet or 1 foot each. What you do is you give the person who needs the lift 2 or 3 feet, and the person who's 7 feet tall doesn't need a lift. In other words, racial equality is premised on the idea that context matters, versus liberal equality, which defines equality as same treatment. In other words, everyone gets the same size lift. That's what equality looks like, because it's all about the process, not about the outcome. If you can't see after we give you after you're given something to help you see, if you can't participate even after you've gotten the exact same thing someone else has, well, that's on you. Figure it out. Ends are not the focus for liberal equality. Ends are the focus for racial equality, equality of races. Liberal equality just cares about same treatment. Now, there are many people who've written on liberal equality, and there are many of us who write on racial equality as sort of the ideal under the 14th Amendment Equal Protection Clause. The point here is simply this: sameness was the backdrop to the Plessy versus Ferguson case. Separate but equal. Now, this case is legendary in American law, but is probably best understood based on the fact that Brown versus Board of Education overruled it, right? In the popular imagination, it's understood that Plessy versus Ferguson, or Brown ended separate but equal, but Plessy, the separate but equal prong, needs to be explored. This concern in Plessy was that, segregated rail cars, literally segregated rail cars, where somebody who was not, easily identified as Black was arrested for riding in the white section of the rail car. And it was strategic litigation. He went in there with the expectation he'll be arrested. And he went in there after being arrested, expecting to sort of overturn in 1896 what seemed to be, to him and others who were supporting this push, an unconstitutional law of segregation in the state of Louisiana. However, the court found otherwise. It said, as long as the rail cars for whites and Blacks were comparable, were equal, it was okay to segregate, because the Equal Protection Clause does not require that we not segregate. It only requires that we have equal access to the same stuff. That's the type of argument that actually sadly resonates probably more now today than ever before in my lifetime. Because the problem with that is that it leaves out the obvious. Separation is a way of identifying who's higher and who's lower. Every time we separate, there is a judgment being made. In the context of race, in 1896, not too long after the Civil War, it was obvious what was being reinforced: the racial caste system. But this was Plessy, and this undid. This is one of those cases that undid so much of what the framers of the 14th Amendment were pushing for. Now, there are other cases I can talk about ad nauseum, but I do want to sort of highlight that this case in particular is specifically relevant for Brown versus Board of Education. Now, I do want to sort of identify some of the key problems with liberal equality, make sure I summarize those for you. The mechanical application of rules divorced from context ultimately undermines the goal of racial equality, the goal of the Equal Protection Clause. And actually, as you go forward, doesn't just undermine the goals of the Equal Protection Clause, ultimately can reverse it. And we'll talk about that in the next section. But before we do that, let me tell you about Brown. Separate but equal is inherently unequal. Brown embraces racial equality in 1954, how many years after 1896, right? You have finally an embrace of racial equality. And during this period from 1954 through to the late 60s, early 70s, you have a court that is willing to reinforce a structure, or at least create a legal structure, or reinforce the 14th Amendment Equal Protection Clause original legal structure of furthering racial equality. Brown is the first to end segregation in the context of education, but this snowballs into something else. The thing I want to make sure I'm clear about is there was a recognition in Brown of the social impact on Black children when they're segregated from white children. Feelings of inferiority are imposed on them. Now, I want to sort of highlight something, right? In the context of adults, this is frequently dismissed as, well, you have to stand up for yourself. You have to be strong and have a sense of self that goes beyond what other people say about you. If you're feeling bad, that's on you. That's not about the law. That's not about structures. That's about you having an issue that the law can do nothing about. When it came to children, the fallacy of their argument became all the more clear. The point that schools, public schools, are there to inculcate values and shape the minds of children highlighted the reality that this was a pretty bad system. This was a system that was literally imposing ideas of inferiority and doing so whether good people, good white people, good non-white people wanted to or not. And the court said the Constitution cannot stand for that. So moving on now to privileging the privileged. So I want to highlight in this section, I'm sorry, I moved too fast. In this section, I'll be discussing some of the most recent research for an article that I'm currently preparing to publish, titled The Walk Away from Equality. I'm playing around with the title a little bit, either walk away from equality or be the walk away from racial equality. But the point is this idea that we have walked away from the framers' intent when passing the Equal Protection Clause to the 14th Amendment. So speaking about structure, I want to highlight what Milliken versus Bradley does. This was a case out of Michigan where you had white parents who moved to a suburb in order to effectively self-segregate. So their kids don't have to go to school with those bad kids, those bad Black kids in Detroit, right? I think this is the type of language that is frequently heard all over the country. And I want to let you know, in 1974, you had a case that provided legal support to allow this to happen without having to worry about the fear of having some kids being bussed in from another school district. This case held that it was unconstitutional for there to be a busing remedy between school districts. Now, this case limited the power of the court to impose desegregation options and effectively allowed for white flight, arguably actually encouraged white flight. And I use the word de facto segregation for those of you who are familiar with the law. De jure segregation would have been what you saw in Plessy, right? De facto segregation is what you see going forward. People choosing to, with their own private liberty interests, freedom, right? Some John C. Calhoun on liberty type of stuff, to say that we're going to be free to be racially discriminatory. Or in a more palatable way, you're free to take your kids and move to the best school district. In this sense, we've privileged liberty over racial equality, and in the context of this specific case, encourage white flight to the Detroit suburbs. And for those of you who don't know, Detroit today is a very Black space, also very economically depressed. And a lot of cities experienced this white flight in the 70s into the 80s. And those of you who've lived in the United States for some time know of the urban blight that occurred during the 80s, 90s, and the urban renewal that has occurred as whites have returned to the city and the gentrification issues attendant to that. In other words, the pushing out of the longtime Black residents, Black and brown residents of those cities. So what we have here is a 21st century Plessy that I want to highlight. So not only are we in a situation where we've now allowed for de facto segregation, good people who want to correct for racial discrimination or racial segregation can't even do so when they come together in their school district, because under parents involved versus the Seattle school district, you can't have a school reassignment plan that explicitly tries to balance race. Here you had an attempt to balance race by way of assigning students to schools and using as one of the tiebreakers the concern of, okay, is this school white, more than 60% white, or is it less than 40% Black? If so, we're going to, sort of use it as a tiebreaker to get kids into the more popular high schools. Instead, the court said you can't do that. That violates the Equal Protection Clause. I want to highlight that everything is turned on its head at this point. Racial equality is not allowed. The Equal Protection Clause now bars remedying racial inequality. This is not something you get from reading the 14th Amendment, by the way. This is something you get by way of interpretation that's hostile to furthering racial equality. So now you have the quality of education being undermined by privilege, and privilege is being reinforced by the law, even when the privileged are opting to try to do something different, thereby reinforcing existing social hierarchies. Now let's turn to right now. The pandemic has clearly exacerbated existing inequalities. You're aware of many of the things that are going on in the health context that's been widely reported. In the education context, the existence of pandemic pods has some racial equity concerns buried in them because pandemic pods are not free. This data I have here shows, and I'll just highlight a few things here. And this is from learningpods.com, learning-pods.com, where you can go to enroll in a learning pod or pandemic pod. And the organization will assign you a teacher based on the family's academic needs. So price per pupil for, if you want your child to be part of a 3-person pod, is $4,427 a month. That's for private education. That's for tutoring, supplementing what you're learning in school, K through 5. And that's unaffordable for a lot of folks. And if you want to sort of consider the wealth issues, it's clearly unaffordable. I'm not saying that every poor person or every rich person is of a certain race, but it is well known. We don't have to do a detailed analysis right now during this discussion to know that disproportionate numbers of people who could afford this are white. Disproportionate percentage are white. Disproportionate percentage the disproportionate percentage of non-whites cannot afford this sort of thing for their kids. Of course, if your kid is going to preschool, you have a deal of you only have to pay just under $3,000 a month to have them educated. So I want us to consider the irony and the complicity. You don't have to be a bad person to want your kids to have a good school, a good education, right? But here we are in the midst of a national reckoning with white supremacy, and we have the expansion of inequality in the context of these pandemic pods, learning pods. And often it's involving well-intentioned parents. In this sense, we're all complicit. We're all part of the original sin. And the original sin is just getting bigger because of the inertia of these established rules. The structure makes us a part of something we may not want to be a part of. Not knowing this does not reduce the impact. Unless we are working to disrupt this, we are reinforcing privilege and inequality. So, racial equality in STEM education, I'm sure you are aware of this, but Blacks and Hispanics or Latinx made up around 27% of the overall US workforce as of 2016, but together they account for only 16% of those employed in STEM occupations. Past studies have raised a number of possible reasons for this underrepresentation, including the need for racially and ethnically diverse mentors to attract Black and Hispanics to these jobs. However, I'm going to suggest something a little bit different, right? I'm going to suggest that access, power, wealth, and stereotypes contribute to this. I'm going to suggest to you that institutional realities that predate going to college and in some cases have nothing to do with whether the students are capable or not, bar this possibility for so many. You know, it's interesting as a law professor, I can say that, you know, a lot of people will dream about as children, whether they have the background in their family or not, of being a lawyer or a doctor. Okay, probably a doctor first, right? But the bottom line is a lot of people know about certain professions. Engineering, STEM jobs, that's something you have to have access and power to know about. And I think you had a previous speaker that discussed this in more detail, but I do want to highlight that this is all connected. As is this concern about how to disrupt racial privilege in education. I would suggest that we push for public solutions to education challenges, public engagement, focus on institutional actions and results rather than individual intentions. And finally, and this is sort of my life's work, support constitutionalizing a federal right to public education that clearly and explicitly moves us past this strange and distorted intent analysis and really gets to the core. Every child deserves access to high quality public education. With that, we've finished our discussion of privileging the privilege. And I'm looking forward to hearing your questions and engaging in discussion. Thank you.
Thank you. Thank you so much. And I'm sure that if we could applaud, there would be a round of hands going up in applause right now. And I can tell that from the questions that have been coming in throughout the talk. I actually have 2 or 3 of my own, so I'm going to sprinkle them in amongst those that the audience has asked. And I'm going to start with one on private schools. What role would you say private schools, and I think you got to this at the end, play in further worsening educational inequalities between Black and white students? Should private schools even exist? It's not a yes or no question.
Well, so that's a fascinating question because it depends on so many factors, right? So for example, in the context of charter schools, there's long been a movement to, well, many of us are familiar with the recent movement in recent years to have charter schools and the concern it draws money away from public schools that in the same area. One thing that is not known as well by most people is after Brown v. Board of Education, there was a long period of time where the southern states fought to allow for segregation in their schools. And when they failed, they tried many different strategies, including the Southern Day School movement, which many scholars recognize as sort of the, at least the intellectual, if not actual, forebearers of the charter school movement today. The idea being that, okay, we'll defund the public schools entirely and instead send discrete state funds to these private schools. So in that sense, if you look at it from that perspective, it's obvious that the original push for what we now call charter schools was to undermine racial equality. But it doesn't have to be that way, right? There are strategies for furthering racial equality by way of charter schools. But it's worth noting that charter schools do have that ugly history that they have to overcome.
That's really helpful. We have another question. I'm not sure I totally understand. I'm going to read it to you. How does housing segregation, such as in Missouri, play into education equality?
Great question. So if you consider the Brown case, right, and the idea of inferiority being imposed when you have a law that bars Black students from going to school, white students, the idea being that, okay, well, we're not good enough. I'm not good enough. That's why I can't be with the white kids, or the white kids have all this stuff and we don't. And if you look at that of Brown just by itself, then the only difference between, and Derek Bell, the late great Derek Bell, wrote about this in his book, And We Are Not Saved. All you've changed now is, instead of it being by law, it's segregation by fact, right? So rather than simply saying you can't be there because the law says so, now it's like, okay, you have to stay in your neighborhood because your family is not rich enough to go to send you to a better school. So you're less because of that. Arguably, that's even more traumatizing, right? At least you can look at the law and, as you grow older, say, okay, this is a bad system. But to now be in a situation where you just look at your parents and say, well, I guess I come from a bad lineage. So yeah, I would say that's one of the biggest challenges in terms of just the developmental concerns. But other concerns include, and let's be clear here, prior to Brown versus Board of Education, separate was not equal, right? Separate was inherently unequal. That was the point of Brown. They were always doing these things to further inequality in funding and everything else. And then you think about how are schools funded. The funding formulas for schools involves looking at, in most cases, in part looking at the real estate, the value of the real estate, the value of the land in that space. Well, anyone who's lived in America for 5 minutes knows that if you see a lot of Black folks in the space, the land probably isn't worth that much, irrespective of who's living there. And there's been so many urban studies literature, so much urban studies literature on this fact that large retailers, if you're looking at retail or other people who bring value to a space, will avoid comparably affluent Black areas and preference going to white areas. So the tax base gets messed up when you have segregated spaces, unless we actively work to disrupt that. Don't normalize wealth-based funding of education. One solution is you do a full statewide funding of education, or what I would suggest is a national mandate by way of a federal constitutional right to public education. Look, the way things are is not the way things have to be, nor is it how they have to remain. With this insight, we can look beyond the United States and see how things are funded in other countries. We can look beyond our own community and see just how they're funded in other states and cities.
So there's actually a comment from Kelly Cross supporting some of what you just described, which is that housing is tied to property taxes, which support district funding. So in fact, exactly, just reinforcing your point that wealth-based funding of education is problematic.
Okay, thank you, Professor Cross. I appreciate your insights, and I'm looking forward to your talk.
There are so many other questions coming in. I don't know if I'm going to be able to throw my question in there. I apologize to everyone, but I am going to throw a question in there because I got very intrigued in the very beginning when you described what a fundamental right is. And prior to 1861, right, there was absolutely no fundamental right to education for Black citizens, I guess, slaves, right? Prior to the start of the Civil War, there was no fundamental right.
Well, arguably there still isn't.
Right, but in other countries that don't have that history, right, where they haven't had that separation and understanding, denial of a fundamental right going back to 1861 or so, do we see different models and different systems that are not associated with the same inequities?
All right. So one of the things the U.S. unfortunately inherited was a feudalistic perspective on education, at least in the southern United States. So what you see coming out of certain spaces in Europe is this idea of more of the wealth-based idea. So what I said about the Southern planters and the poor whites not seeing a value in education was sort of the norm in many other spaces and places for so long. Without getting into too much detail about sort of what feudalism looked like in Europe versus what things look like in some other parts of the world, that I'll sort of stay in my lane and just simply suggest that as a common law country, we model much of what the Britons did or the British did. But because they're more homogenous, their segregation and discrimination oftentimes look more like a class-based thing. And in the US, we replicated that and mapped on race in a way that they could never have imagined possible.
Very helpful. So there are still quite a few questions. I think we're eventually going to have to take some of these offline by typing them, but I'm going to read one out about higher education. To what extent do approaches to address economic inequality through financial aid and scholarships address or not address racial inequality?
Okay, so here's the challenge we're all working with, and this is because I love the way the questioner is thinking, right? But the challenge is that under the law, as it currently exists, it's difficult to do, not impossible, and I'm happy to strategize with you trying to do work on this, but it's difficult to do direct payments based on race. So you have to do all these qualifiers to address it. And in some ways, that's advantageous to the greater cause for equality, right? Because class-based equality does exist. Poor whites are, in many situations, socially Black. So I don't want to lose sight of that reality, especially in a state like Missouri, where that's sometimes sort of obfuscated and thereby leads to folks pursuing interests that are divergent from what their real preferences are. Unity sort of was a theme to one of the oldest cases in American law, creating slavery, right? Where you have in the Punch case, that was, shouldn't say exactly American law, it predates the United States of America, but the Punch case where you had a group of people trying to, indentured servants trying to revolt, and the Black one gets slavery for life, and that's the first American slave, and the other indentured servants just get their time extended. So just to circle back to this idea of financial aid, I think financial aid could be helpful, but oftentimes the goals sort of get confused. The goals get confused, and sometimes there'll be a discussion of, well, we should give it to the person who has the highest score, who's the best, who is the most qualified. And that word qualified is so loaded because it's qualified in what context?
I guess I also throw in there, does financial aid is it designed to achieve this liberal equality, right? Or is it really striving to achieve a racial equality? If it's race-based financial aid, which is another issue, but right, what is it actually designed to do?
I love that you use that tagline, right? The difference between racial and liberal equality is so central to the aims of financial aid. And I would suggest that you could do both, right? Well, not both racial and liberal equality, but you can actually advance racial equality as well as advance those things that are proxies for race. So that those who are socially Black also are uplifted. And you're not sort of reinforcing the existing hierarchies. Look, poor whites and poor Blacks have the same lot effectively. Just one group potentially can move out, and they're fed the ideology that you have a chance. At least you're better than that person. But the reality is, and there's been so much discussion about the end of American mobility. The reality is most of us are stuck multi-generationally in our classes, notwithstanding the myth that many of us are fed.
Okay, I think we have 5 minutes left. I'm going to take two different questions from two different people and combine it into one. Okay. So we have a question about whether or not the political leaning of the judge or judges affected some of the decisions that you mentioned. And why I think that's related to the other question is when white people are involved in upholding these laws, what are some of these solutions to laws that perpetuate the racist policies? So sort of, I think the question is, are the political leanings or is the background of the judge affecting the legislature, and how do we change that to overcome these racist laws?
So absolutely, judges are human beings, right? Even the best of judges do not necessarily transcend the moment that they live in. So there was a beautiful dissent in Plessy versus Ferguson that Professor Anthony Farley has written an article on. Law Professor Anthony Farley wrote an article on discussing how that dissent was one of the most racist pieces of writing you'll ever see. The liberal dissent in Plessy basically said, we don't need to do this separation. White people are always going to be better. We've already demonstrated ourselves to be that way. We'll always be that way. So you have that written in, and there's many other things that are written that are really nice, but the point is that even judges who see themselves as liberal, see themselves as sort of progressive, or see themselves as sort of anti-racist, being well-intentioned does not help you escape completely the realities of the space and time we live in, so that the ultimate goal has to be one of diversity, right? And I'm not just talking about some faux intellectual diversity. We have liberals and Republicans. We have Democrats and Republicans. Yeah, it's fake. What you're really essentially saying when you say that is we have, if they're all white, we have the liberal side of white supremacy and the conservative side of white supremacy. You know, that doesn't solve anything until you actually have diversity, real diversity, and context matters. Diversity is not an abstraction. Diversity is, in the context of race, about race. And pretending otherwise, obscuring that, undermines the possibilities for ultimately moving past this. You don't turn around and say, well, I'm just going to be colorblind and not see that a bunch of poor folks are Black. I'm just going to see that they're poor folks. Well, what does that do? Well, if you pretend that they're not Black and then you realize they're Black, you say, well, and you don't even think about the context, well, then that just reinforces something really, really problematic. They're there because they didn't work hard enough, or they're there because of whatever other reason sort of reinforces the popular mythology of meritocracy. And I write about this a bit in The Fifth Freedom.
All right, well, I think we are out of time for the seminar portion of your presentation, but I think there are many more questions that have not been answered that you have an opportunity, if you want to take 3 or 4 minutes now, to answer by through typing. But I'm going to close the session. Thank the speaker so much. Thank the audience for your participation. Point to the chat, that in the chat, not in the Q&A, but in the chat, there is a link to the Zoom room where my co-host, my co-moderator, Jessica Wagenseal, is waiting to welcome you, and will introduce the ground rules for discussion of today's seminar.
Great.
So with that,
if I could just say thank you for the opportunity to share these ideas, and thank you to you, Lori, and everybody involved in organizing this series. I do believe this is crucially important to have these discussions and conversations, and thank you for being a platform for doing so.
delighted to do so. We learned so much, so thank you, please. And join us. I hope Professor Imoukhuede will join us in the breakout rooms and participate in some of the discussion. But with that, I'm going to turn it over to the facilitators. I'm going to stay in here with Professor Imoukhuede, and I'm going to encourage people to head out to the other Zoom room. Is that right, Tammy?
Yes, that's right. We have that room open right now.
Okay, very